I'm very glad to be here. I'm actually even more glad to be here now as first speaker, because I was actually probably the last one in the boat, because I actually submitted my abstract a couple of days late. But then Simon very kindly said, "Oh, we can still include you if you want to come." And I said, "Oh, yes, please." So having done that, I'm slightly surprised to be the first speaker on the block, as it were. Now, yes. What I'd like to do, and I don't want to digress too much, because I do want to I really want to try to make this first presentation a kind of outline to raise issues and questions, because in truth, this is also a continuing research project for me. So I've certainly not come to the end of it yet. And indeed, as you'll see from some of the litigation that I'm following now, the results, these are cases or complaints mechanisms which are being utilized as we speak, more or less from 2018 running on to 2019. So several of these have not been fully resolved yet, and so therefore my research is also continuing in that respect. Now, as Simon rightly introduced, what I'm going to try to do today is really cover the alternatives which seem to have sprung up in light of what some might call the total market failure of the actual international regime. Now, I speak as an international lawyer first and foremost, and an environmental lawyer latterly. And it is quite instructive to see the amount of work that has gone into constructing an international regime, the global climate change regime, in the form of a framework convention. We then had the Kyoto Protocol. We then had the Paris Agreement, ever more specifying the targets, the actions that need to be undertaken. And yet the world as a whole, but especially the most prolific, shall we say, emitters of carbon around the world, seem to be taking very little heed. And in some cases, they are actually actively denying the scientific facts behind what we, generally speaking, should really now all accept as global climate change causing global environmental and, in some cases, arguably disastrous events. So what I want to do is explore how despite the relative, I would say, some might say, reality of failure of the international regime, we nevertheless see that a new normative framework has emerged. I'd like to emphasize that. So, those of you who are not international lawyers will possibly say, yes, here we go again. International law, not really law, possibly. Yes, I take that criticism, because I'm afraid the international regime, certainly in relation to climate change, doesn't seem to be working very well at all. But what I mean by a new normative framework is that we seem to have now, through various sectors, and I'm going to be highlighting a couple of these sectors in a few moments, an understanding that things need to be done in relation to the carbon emissions from various different sectors of society below or even beside state level. So the level of states and governments. So the international regime, of course, is directed towards trying to embody commitments on the part of states. But what we see now with the new normative framework on climate change is that actually the individual actors, whether they be international organizations or even transnational companies, and the two industries in particular, or two or three industries that I want to highlight in particular, obviously the fossil fuel industries, the large oil and gas multinational companies have had to, in fact, reflect very much on their carbon emissions, on their contributions across their everything from their upstream to their downstream activities as to their climate change responsibilities. But what we are seeing now here is an evolution of that norm, if you like, to industries which are also, one might argue, enablers of the fossil fuel industry. Now, we're used to sort of seeing fossil fuel companies like the Shells and the Exxon Mobils of this world as being huge entities that are all powerful in their own right. But in actual fact, they're still beholden to large amounts of investors. Investors in the form of shareholders, but also especially investors in the form of asset managers and other types of investment finance companies. Please forgive me if my nomenclature is deficient in this way, because I'm still feeling my way around this area as to how to actually define these shareholders as well. They're not, Auntie May from Oklahoma. They're not just Auntie May from Oklahoma having a few shares in Texaco, for example. These are literally, we're not even talking billion or multi-billion or even hundreds of billions. We are talking about trillions of US dollars worth in assets. And they can pretty much govern. I'm not suggesting that they control huge companies like ExxonMobil or Shell, but they can certainly exert, perhaps control is the wrong word there, but they can certainly influence even more the activities of fossil fuel companies like ExxonMobil or Shell that we often think of as being entities that are autonomous in themselves. So I think it's very important for us to realize that the normative framework I'm suggesting, or the climate change norm, indeed climate change emergency norm, is actually with us now and slowly devolving into these areas. So I'm just going to, sorry, may I put it the wrong way? Yes. Oh, no, I'm going the wrong way. Sorry, I'm just going the wrong way. Here we are. Can I get back to the? Thank you. Okay. I could have used the form. Yeah, excellent, excellent. Okay, thank you. Yeah, right. So, apologies for that. I'm used to using the mouse. So, what we have? So we have actually, just to go back again. No. I think I'll just do it here. Yes. Just so two types of responses that I want to emphasize. One. These international organizations and transnational entities. And I do want to highlight, again, part of the exercise that I want to undertake with this talk and with the paper that I want to develop from this is also an exercise which international lawyers in particular, and international environmental lawyers, tend to want to do. And lawyers generally, I think, would like to do as well. We like to sort of look at how a new as I say, normative framework is developing, but also undertake a categorization exercise. So it's important to see actually the different types of actors that are beginning to be imbued by this new normative framework. So we talk about international organizations, and by that we mean public international organizations. So you see that I'm highlighting the International Finance Corporation of the World Bank Group, but then also other international organizations like the Bank of International Settlements, and of course the EU in many cases acts like an international organization as well. But then we also see, as I've already mentioned, private transnational, what I would call transnational investment finance and asset management firms. So what we see here therefore is that normative framework evolving into public sector organizations as well as private entities. But then at the very end of that process, as we're going through, we see that it starts getting mixed up, especially, for example, when we consider the asset management firms that I've highlighted there. We see that actually we go into public and private because they are obviously public pension, especially in the form of pension. We're public pension funds, but then also private pension funds. So I was actually surprised to see that our own university superannuation fund that we are all part of is considered a private pension fund. I always thought it was a public fund, but actually apparently it's called a private. It's regarded as a private pension fund. So that's the first category, prescriptive. And then secondly, I want to look at, and I hadn't realized that Simon was going to be very keen on this, so I'll be looking for issues and questions that Simon raises, especially the various different types of litigation. And again, the categorization issue that I would like to explore is the different types of litigation. Litigation against whom? We'll see that there's been litigation against obviously the fossil fuel companies, but also states, and even now pension funds themselves, as to their transparency and their awareness of climate change risk issues. So what's very interesting is how this normative framework is devolving into a myriad of different types of actions. And to me, that is a strength and a weakness. It's a strength in the sense that it tells us that it is now something which is evolving away from the straightforward international legal framework that international lawyers initially wanted to introduce, which was of course directed at states fulfilling their obligations and then implementing those obligations to all the entities operating within their territorial jurisdictions especially, and as far as they could control entities that were operating outside their jurisdictions, for example, like shipping or aircraft, right? As well as, of course, transnational companies that might be operating abroad outside their territorial jurisdictions. What we see now is that this climate change norm, if I can put it that way, or climate change emergency norm, is devolving to actors which, in spite of or despite their distance from the government. In other words, they are not beholden necessarily to the government in order to uphold this climate change norm anymore. They're taking it on board themselves. So there is an element of self-regulation here, but that of course comes with all the caveats of self-regulation. How are these entities then introducing first of all, introducing and abiding by their self-regulation? Well, that falls, I think, within the first category, the prescriptive element. How are they going about their prescriptive understanding of the climate change challenge and the broader sustainable investment challenge that they are facing? And then how are they being forced to address these issues is going to be the subject of the second part. So the specifics, again, I'm going to highlight generally. As we can see here, the prescriptive measures are in the form of lawmaking / law adoption measures. And for example, with the IFC, now just a quick word of explanation for people who may not be so familiar with the role of the IFC. The IFC, the International Finance Corporation, actually assists not really states, but companies that undertake, in particular, major infrastructure projects all around the world. So although it's a branch of the World Bank Group, it's actually still a public international organization within the World Bank Group. And although it's slightly confusing in the sense that it's called the International Finance Corporation, suggesting that it's a company, or the shareholders are actually, in fact, the shareholders of the World Bank, i.e. the members of the World Bank, the states of the World Bank. That's now come out with the operating principles for impact investment management. Now, within those operating principles, you'd be hard-pressed to look for the word or to find the word climate change. But the whole thrust of these principles is to try to ensure that the IFC now commits its funding and or technical assistance. So the IFC assists companies working in many different jurisdictions through two main methods, usually through some form of funding support, but also by providing technical support. So IFC personnel, professionals, go forth, as it were, and advise the companies that are working, that are conducting infrastructure projects, in particular in many different countries, as to what they can do. Now, the difference here is that impact investment is meant to be, and again here I'm couching my words carefully because I'm inviting comment and criticism really from all of you in the audience, because we have to look at these prescriptive elements of lawmaking and law adoption carefully. They are ultimately exercises in self-regulation, so all the questions come out. So they are presumptively proactive. In other words, it's not just to be the case that individuals, or rather companies, are meant to be ensured that they reduce their carbon emissions, for example. So that's an example of an obligation where you're supposed to reduce your activity which is causing pollution or causing, in this case, climate change. But in fact, to be proactive and ensure that the project itself is going to be environmentally enhancing, as it were, is going to meet Sustainable Development Goals, the SDGs, etc. Now that's a whole different kettle of fish, if you don't mind me suggesting. It means that the means to verify that the investment is actually making a positive impact on environment and social and other types of meeting other types of goals is actually to be measured, to be ensured, and arguably should be done even before the project begins, right? The project should almost guarantee a positive impact. And so that's going to be very interesting to see how that plays out. That is literally from October 2018, the draft, and I think it's just come into force in late 2018. So again, it's something we're seeing going into 2019. We're going to have to see how it's being implemented and what is the comeback for that. And just very quickly, because I have more time, the International Finance Corporation has an ombudsman office where, in fact, complaints can be made if, in fact, it is found that these impact investment principles are not being adhered to. So that's going to be very interesting. The task force that was established by the Financial Stability Board of the Bank of International Settlements, which was, by the way, headed by the current, I think he's outgoing now, is it George, sorry, I've just forgotten his surname, Carney, is it? The Bank of England director, in fact recommended that that central banks everywhere start requiring climate-related financial disclosures. So again, we see here central banks getting in onto X. You see, entities that we would never really have expected to be considering how to introduce climate change risk information to be reported on in order to enhance transparency are actively considering this. And so the task force has recommended that to the Financial Stability Board, and the Bank of International Settlements is basically the international organization governing central banks and equivalent authorities across the world. So again, we're going to see movement on that. The European Commission has a proposal for a regulation on the establishment of a framework to facilitate sustainable investment. And of course, embedded within that notion of sustainable investment would also be climate change risk related investment. But what I want to emphasize is the private side, which is the last bit on this particular slide, right? How are they going about it? Well, they're emphasizing, they are placing an emphasis on environmental, social, and governance criteria. So they folded the climate change risk issue into environmental, social, and governance criteria. That can have its own downsides, because that might mean that it becomes simply one measurement within a whole range of indexes that the companies pay attention to. But what is important here again is that they are committing, and here's the scope for real change, they are committing literally trillions of funds to what they call exchange traded funds, which are designed to try to find their way to projects across the world, infrastructure projects, other types of projects which would normally have an impact on the environment, which is, even if it is accounted for, it is accounted for after the event. Whereas now, we're coming in at the start. The investment itself has to ascertain, has to be ascertained as being of a positive ESG, as meeting positive ESG criteria. again, we are confronted by the fact that the measurement of this, and in particular the establishment of the specific criteria, is still to be done, but then the measurement of whether in fact companies implementing, gaining the investment in order to implement their projects will actually be able to meet these ESG criteria and therefore be able to show positive impacts on these criteria is yet to be ascertained, I would suggest. Right, I'll skip over this one. This is basically to show you the pathway for the operating principles, and it would need to really to be expanded. And I think despite my efforts, I think I'm also slowly running out of time. So I want to get to the second part, which is the litigation element. Now, as this first speaker, obviously got the privilege of being able to mention all of these the first time, but I'm going to restrain myself to highlight, I think, some of the cases that people are less familiar with. The case that I'm sure leaps out to everybody's attention is the Urgenda litigation against the Netherlands government, where Urgenda highlighted various conventional rights under the European Convention on Human Rights, as provided also within the Netherlands Constitution, I believe, in order to claim that the Netherlands government really should be doing more to meet its climate emissions targets, its own climate emissions targets, but also to be doing more to mitigate the negative effects of climate change across the world. So it's a pretty hefty challenge to the Dutch government, and of course the Dutch government is, generally speaking, a good and responsible actor on the international stage on these issues. So it's quite interesting how that litigation is forcing the Dutch government arguably to do even more. I'll leave that because I'm sure other people will be talking about it as well. But I wanted to highlight, and I'm not sure whether everybody in the room is familiar with the Greenpeace case against Greenpeace, and in conjunction with, I should say, a local Norwegian partner NGO as well, civil society organization, and they are challenged against the Norwegian government, and also the Gloucester Resources case, which, as you can see, also is from 2019. So these are all very recent cases, the ramifications of which I'm slowly sort of unraveling in my own research. So I'm happy to take questions, but I think there may be people in the room who actually know more about these cases than I do. What I want to highlight is, again, the different kinds of challenges. And again, we go back to this categorization element that I want to try to introduce as a sort of overarching framework to try to analyze these developments. Greenpeace then challenged Norway on the basis that since the Norwegian constitution has words saying, talking about sustainable development, etc., that they should therefore in fact not be opening new licensing areas on the Norwegian continental shelf for oil and gas operations. Now that's a very interesting challenge, because it's saying, well, if you are really going to implement these principles in your constitution and you're committed towards reducing your greenhouse gas emissions, then you should actually, in fact, as is the well-known phrase, keep it in the ground. You should not be opening up new acreage in your continental shelf for oil and gas. And unfortunately, they've lost, although I believe an appeal is going to be made to the Norwegian Supreme Court. So I don't think unless somebody here will is going to update me, I don't think the case has come before the Norwegian Supreme Court yet. But that's going to be very interesting to follow, because Greenpeace have obviously hit on a very tender spot for the Norwegians. They are one of the largest oil and gas producers, yet they're also apparently equally committed towards sustainable development, and indeed within that context, obviously mitigating or reducing the impact of climate change. So that's an interesting challenge against the government. And again, here the categorization process I was talking about, these are litigations against state governments. Now, whether we can include Gloucester within this category, and here I'm struggling, I know, is a different matter. People here, I'm sure, I can see a few knowing glances. People here will know about Gloucester Resources, where the Gloucester Resources, in fact, had been refused permission to open what I think was a coal mine in New South Wales, in Australia. And they challenged that refusal of permission by the licensing authority in New South Wales on the basis that the decision was at least partly based on their presumed emissions, clearly the coal mine isn't actually in operation yet, presumed emissions, their presumed contribution to carbon emissions, which would obviously increase carbon emissions globally. Now, what's interesting is that the court refused, it's also an appeal, I believe, I think, refused their application on the basis that at least one aspect of their operation would in fact be contributing towards carbon emissions, and therefore, as it were, at this point in time, they would not be allowed to carry on. Now, the judge in the court, in the relevant court, New South Wales court, did emphasize that their putative contribution to climate change through carbon emissions and therefore climate change was only part of his decision. But nevertheless, that again is showing us that the normative development of climate change related risk is, as it were, evolving or permeating various different kinds of legal action. Again, I think a lot of people will know about the New York state government litigation against ExxonMobil in, I think, the very active Manhattan. I think it's called the South Manhattan, or it's the lower. That's right. I think it's the lower Manhattan, not the Southern Manhattan. The lower Manhattan courts, where in fact ExxonMobil is being sued under the New York State Martin Act for corporate misrepresentation. Basically, again, they developed two different prices for the cost of reducing their carbon emissions. And the reason why they did that, as alleged by the prosecutors in the Lower Manhattan court, is in order to gain some probably sort of tax-related cost implications with the higher price, whereas showing a lower carbon price to their shareholders in order to ensure that their share price on the stock market remained relatively high. So there's been an alleged misrepresentation of their carbon pricing policy, basically, and that then arguably actually is, I believe, would be a crime under the Martin Act. So that's one to also look at very quickly. And then we have the even more interesting cases here of challenges, some in the courts, but one in the court, the McVeigh versus the Rest case is before the courts, I believe, again in Australian court. And then the other one is back here in the UK, and it's Christoph Harwood against the Shell Contributory Pension Fund. So very quickly, the McVeigh one, which is I think introduced towards the end of 2018 and is going through the court at the moment. I don't believe we've got, I'm just looking to the audience, to people who might well know more than me. Again, a result with that. But McVeigh is suing the Rest, as it were, the Retail Employees Superannuation Trust, for more information and to find out what they're actually doing in terms of their investments on his behalf as an employee who's contributed to the Rest pension fund, superannuation fund, in order to ensure that they are investing, basically his and all other employees, retail employees contributing to the fund's pensions, in climate change risk averse investments, and in fact being transparent about that practice as well. So he's asking for that to be showed, and the case is going on before an Australian court. Now, to show you the variety of litigation strategies, we should emphasize the last case, Christoph Harwood. Now, he's being assisted by Client Earth, and he's actually I have checked the Pension Ombudsman's website, so apparently the complaint hasn't actually been brought to the Ombudsman yet. But the significance here is if the Pensions Ombudsman of the UK in fact agrees with his complaint, then it becomes a legally binding decision, as in the court of law. I believe as having the same effect as a court of law. So again, we see here the variety of litigation, the variety of legal responses, and he's being assisted by Client Earth. I'm also just trying to get in touch with the lady, I think her name is Joanne Atherton of Client Earth, who is assisting him in this possible complaint against the UK Pensions Ombudsman. And again, very similar to McVeigh, they are asking what the Shell Contributory Pension Fund is doing, first of all, to ensure that investments, and of course everybody here I'm sure will appreciate the irony, that the Shell Contributory Fund is not going to be investing in climate change risk related investments, and also what it's going to be doing to try to ensure that its mother company, as it were, is actually going to be moving away from fossil fuel based activities to renewable energies. Right. So I think that brings me to my concluding remarks. The relative failure of the treaty-based regime, instead of then continuing as a failure and continuing with delegates knocking their heads against a brick wall, as it were, whenever there's an international conference or the next stage or the next conference of parties for the climate change regime, has instead, perhaps inadvertently, developed a kind of normative framework. I think I'm sure it's not just these delegates, it's not just these states, governments and the NGOs related to them. It's also, for example, things like, people like Greta Thunberg, and Naomi Klein has now come up with a new book. Even locally, I don't know how many of you can see here, there's a call here, I live in, my family home is in Essex, and there's a call here for a local climate strike action next week, right? On Friday next week. Unfortunately, I won't be able to go to it, which is a real shame. But just to show you how the grassroots is really responding in that way. And I think it's their pressure that is actually working its way through the systems. Another thing I just want to very quickly show you, and that this is related again to the Norwegian claim by Greenpeace. Now, it's just escaping yes, that's right. The Norwegian state oil company is called Statoil, but Statoil now is known as Equinor. And again, that's a very interesting name change. It's obviously trying to leave out the word oil from its title, right? So it's now called Equinor. But Equinor then had a poster in the London Underground tube, suggesting that they were a renewable energy company. And that was seen by somebody from, that's right, Mr. Worthy, who I'm sure is very worthy, from the NGO Global Witness, who then complained to the to the UK Advertising Standards Authority, and just yesterday, I think it was, the ads watchdog, again, has wrapped Equinor for over its tube poster and requiring it to withdraw its tube poster, suggesting that it is mainly a renewable energy company, when actually, in fact, it's the Norwegian state oil company, so that most of its activities are actually oil and gas related. Right? So governments, international organizations, as well as major public and private financial institutions are being taken to task, and they are then, through the various means and others, responding to this. There are still huge questions. When we move into the self-regulatory field and when we talk about litigation, we are still not sure that corporate behavior and indeed individual behavior is going to change. So this may also be where we as lawyers have to actually stop and we have to go into possibly the science of psychology. But I think all these are possibly positive developments. And I'm very sorry, I've just found out that Karen Morrow has a cat odor. So I realize now that even jokes can rebound on you. Well, I should know that. But to paraphrase an apt but feline unfriendly, as I've already said, saying there appears to be more than one way to skin the climate change cat. Thank you very much. I hope I haven't taken too much time.
That's brilliant.
Yeah,
thank you very much.